for adjustment of freshman.
We'll take up the matter. Don't worry. Just take up the
Yes, my lord, already adjusted in the Barpali. You also kindly see Annexure 8 and 9.
My lord had
Let me
directed the state to inquire whether
let me complete
was
my.
applicable for
Your also kindly see Annexure 8 and 9. I'll have a glimpse of that. My lord, let me place Annexure 8 and 9.
Give me a page number.
Page number 66.
we do not
Let wait. Let me complete. 66, my lord. 66 page. Okay.
Yes, you have been transferred.
He was transferred and joined in the Barpali. And in the my lord, he joined in Bhotli. After joining in Bhotli, Ranjit Kumar Hasta, respondent 7 was relieved. And under Annexure 9, Ranjit Hasta was adjusted in Gaisilat block, my lord.
Yes.
After both the petitions were disposed of, after granting stay operation of that, he should work at Bhotli and Ranjit Hasta should work at Gaisilat.
Could not get it.
My lord, may I?
What you say, I could not comprehend.
My lord, you understand? Let me complete. I am the appellant. Let me. My lord, transfer. My lord, present appellant was transferred Hinjuli card to Barpali. It's a chain transfer, my lord. Under annexure, your losses can come to page 35, my lord.
I think you should come with one sheet of paper saying that who is going where and how. That will give a clarity because
only
your
30,
name is
only
Kumar
2 days,
Pujari.
my lord, 2 days I am
find
giving.
Saroj
2
Kumar
days, my lord.
Mahapatra.
Saroj Mahapatra has been transferred from Barpali to Bhotli, my lord. He joined on Bhotli.
He is just 1 minute.
Your lordship can come to page 62.
Ramajit Kumar
Hasta, he was adjusted.
He is relieved from this office means
Bhotli.
My lord, actually, there are 3
Let me complete first and let me complete first.
Then look the name Bhotli. No, I am seeing 66 and 67.
My lord, consequent upon joining of Saroj Kumar Mahapatra.
These are two.
My annexure 9 at page 67.
My lord, I am appearing for the has the matter.
67, my lord, your lordship can. Consequent upon joining of the Saroj Kumar Mahapatra, 4/3/2025 order. Assistant Executive Engineer at Bhotli Block on 22/2005 forenoon by notification number so and so, read with order number so and so. Orissa, Sri Ranjit Kumar Hasta is allowed to continue as assistant.
Sir, we have already read. Let me understand with each other.
Yes.
One.
My,
Hasta was not in the
he,
chain of
he was
command.
not in the chain of transfer, my lord. That is why he approached this honorable court. And this honorable court granted stay. He shall not be relieved from his present post of posting, my lord. My lord, he was in Bhotli, my lord. That chain of transfer, my lord, that was my lord. Bhotli.
He was transferred to.
He was never transferred.
Never.
He was never transferred. That Saroj Mahapatra was transferred in the to the place of
How I am surprised
man.
in a transfer matter, the stay is granted.
my lord, he was not relieved because my lord, if that
No,
person
no, I'm
will
just
come to my
asking,
place
where
and
is
beg
the,
of
what,
him
where
to
is
be-
the writ petition?
Lordship,
Where is the writ petition? Of Hasta,
that has
Two
not
five
been-
double zero.
is it pending or disposed of?
Not disposed of common by common judgment.
that
Correct.
common
judgment
What,
is,
what the court says?
Court said to revert back all to their parent post, my lord, without giving me an opportunity of being had.
Parent post means, parent
No,
post,
not parent, previous posting.
I mean, previous posting,
Right.
Previous posting.
everybody.
Everybody.
Then what about the others where there will, the chain would be disturbed?
Disturbed, my lord.
How?
But in this process only I have something. May I clarify?
What is your right? A right of transfer. The transfer is an instrument of service. It is within the administrative control of the authorities how to place his officers in what position. This is within the domain of the administrative officers. How the court, under these circumstances, is there any policy decision? Is there any rule relating to transfer?
No.
How?
my lord,
To
why?
what extent the court?
Your
Then
lordship,
the court should run the administration, not the administrative officer.
But I am not objecting to this letter, please.
Interesting. The judgment against that. That's why I'm saying. He's a regularly appointed. What is Hasda is a regularly appointed employee?
Yes, madam.
Yes, my lord.
Yes, madam.
My lord,
So
I am
he's in
appealing
the
for-
cadre?
Hasda, madam.
He is within the cadre.
And
I am asking one question. Hasda is within the cadre?
Within cadre.
Yes.
You are posted in Gaisilat block.
Can't be done.
No, he was posted in Bhotli block, man.
That's
Hasda
the Gaisilat
was
annexed
continuing in
Whatever,
Bhotli.
whatever I do not
Lord,
find
your
any,
lordship,
where is the judgment?
Well, judgment is at page 10, my lord.
on page 10, madam.
You are Hasda.
I am appearing for Hasda. I am appearing for Hasda, madam.
What right you have?
My lord, what happened, my lord, in this case?
What
Your lordship may
happened
kindly visualize that annexure 1, your lordship may kindly see, page 35. The chain transfer has been made, transferring Saroj Kumar Mahapatra, that is serial number 5, to my place of posting, my lord. But I was not been transferred to anywhere. If
You
he
have
will
been
come
transferred.
join my in my
You have been transferred.
To Gaisilat on annexure 9 at page 67, my lord.
You are is allowed. The Hasda is allowed to continue in
Gaisilat.
Gaisilat block.
no, that has been mixed up, my lord. Your lordship may
What
kindly
mixed
see.
up?
I am just picking up the facts, your lordship, my lord. That serial number 5, Saroj Kumar Mahapatra was continuing in Barpali district, Barpali block, and I was continuing in Bhatli block. When his transfer order was made, he was made transfer to my place, Bhatli. So
So
without
you have to be removed.
no, your lordship, I can.
You have to be removed.
Yes.
So you
That
have been
is-
removed
My
to
lord, that transfer
Gaisilat.
order has never been passed, my lord. That transfer order has never been
Sir,
passed.
this is what a page 67. What is this?
Your lordship, I am coming to that. Lordship,
You
kindly
may
bear-
not be in a common chain of transfer which they publish.
Your lordship, may kindly see
That
what
does not
happened, my lord.
mean that after realizing the administrative some kind of a block, if they have issued a separate order for transfer, does it mean that they have committed any wrong?
That order has been passed during the pendency of the case,
Maybe.
and interim order was continuing.
Maybe.
Was notification number 1 dated 21/1/2025.
My lord, that is under annexure 1, page 35 in the rate appeal.
Read petition.
No, rate appeal rate আছে।
No, read appeal annexure আর নিচু block.
of the interim order?
Interim order I have annexed, my
No cause of
lord.
action shall
My
be
lord,
taken
your lordship's kind
till
comes
Not
to
coercive action.
he is relieved, man.
So
Your lordship
now he has been relieved.
uh, interim
Sir,
order was
coercive
passed on.
action, coercive action means that no
No,
disciplinary
no,
proceeding would be
that is
initiated.
not the order, my lord. The order was, it was directed that in the event the petitioner has not relieved in his present place of posting, he shall not be relieved till next date. After that, what happened, my lord? He was compelled to join in my place. That is why it was directly the contempt of court order. Thereafter, we filed a contempt, and he was transferred to Watley, my lord. He was that opposite party number, respondent number 6, Saroj Kumar Mahapatra. He came and
Why
joined
you
in my
people do not, Mr. Advocate General? Why these kind of an orders are not challenged by the state? Why? You know the law.
Many time I should not say many things, but this administrative orders, your lordship knows it's a very good proposition. Your lordship give it's a settled law. That certain this order of transfer, which is incidental to service, ordinarily should not be unless there is proved malafide
Malafide, there is a
or
proof
the
malafide
authority
or something.
passing the order lacks competency and jurisdiction. These are the two limited grounds
True.
on which it is
True.
to be assumed.
True. True. That's why I'm asking this question.
You know, hundreds of cases are there. I should not Miller, but we are getting it tested in many of the cases that causes administrative dislocation.
Visualize because
And anybody-
it is really a chain transfer.
That's correct.
Somebody is going from here, somebody is coming in his place.
Right,
One is interdicted.
right.
Then the entire
entire
chain gets
chain would-
blocked.
That has happened in this case, man. Ranjit
So
Kumar
that was sought
was
to be
never in
removed.
chain of transfer.
Please, it is you who have created this.
Because my lord, I was nowhere.
It is only for this purposes. Of belief. They don't know how to switch off.
Both
Everybody is suffering, not you.
both of them are currently posted at their places. They are getting salary, but I am hanging in between them. Actually. I have only 3 months of retirement. I have not been posted anywhere.
Just look at, I appreciate the plight of this employee. Because of this, they do not want to use a very harsh word on that. And he's neither posted here nor posted anywhere.
No, my lord, he joined and his joining was accepted, and thereafter, my lord, he was understood in the guideline.
Don't say so. Don't be
My
so
lord,
bold. Sir, the difficulty is you have joined, he has joined, everybody is happy getting a salary.
No,
But for him, there is no post.
But he has
Because
already joined.
the original post which he had is filled up by you.
My lord, your lordship kindly see.
What is this for?
His joining report was accepted at Botley, my lord.
Nothing.
My lord, your lordship kindly see the order, my lord.
There is a
Consequent upon joining of Saroj Kumar Mahapatra, Assistant Executive Engineer of 22-2004.
yes. He is relieved.
No, joined. It was informed to the Jilla person.
First you read the sentence, then you say.
Yes.
The Saroj Mahapatra is joining Hasda, actually Hasda.
Yes, ma'am.
She is representing Hasda.
No.
Sorry, Saroj Mahapatra. He is already there. Saroj Mahapatra. Posted, though he is supposed to go to Bhatli, but Bhatli is occupied. Bhatli is occupied.
Not aware. He was relieved.
Engineer.
Where?
Then a good
Yes.
I was able to join, but after 20 days, I was declared, my acceptance was declared non-accepted. I was told
What?
to go back.
Due to there was an interim order.
It's my notification.
Oh.
Disturbing that interim order, he was compelled to join in High Court.
And then
That's
will
the
declare
answer.
non-acceptance. Now what will
That
happen?
is why the order has been recalled, and I am continuing now in Butler.
After 20.
Mr. Advocate General, what is this?
Strange part.
It is absolutely. The video should have taken up with the government or.
No, your lordship is correct, but the most obnoxious part, your lordship may kindly turn to para 8 of the judgment, impugn judgment. No, that's correct, my lord. But how many transfer orders, my lord? Should I cite
No,
many?
that is what
So
we are.
state, my lord, I
We are
know.
not at one.
I am conscious of the law, my lord, but how many cases? I am asking myself. Writ appeal, I can recommend for filing. Transfer is. So, my lord, your lordship knows, my lord, let me be very bold.
No, Mr. Advocate
So,
General,
I am not
now
going
the
to that.
Please,
But there is.
bear with us for 15
Yes.
seconds. The position now, we will take care of when the other scenario.
One judgment,
other
I
scenario.
will,
But
my lord, rather.
here is the situation that all these persons are placed in such a position
Right, my lord.
that it
Quite bottleneck.
really affects.
Para 8, I was surprised. I had not seen
Saroj
this kind of.
Mahapatra, who joined at the transferred post, but the joining of the transfer post was declared as non-acceptance.
No, you will
Now, where he cannot go to his parent post,
No, true.
he cannot join the transfer
Complete
post.
bottleneck in
He is
Millard,
in
these are
limbo.
all executive engineers. I am surprised, Millard, he has made the arrangement. The entire who is to be posted where.
Nothing.
Millard, para 8 of the judgment.
He is in limbo. Where to go?
So, Millard,
Position. We are not objecting anymore.
Find out that anywhere she is very, very fair. She came, I want to work, I want to join. Put me anywhere. I don't mind. 600 kilometer away or
no,
6 kilometer away.
Your lordship, there is a stay in the writ appeal. That is the reason. The department is handicapped. Lord, there is an entry order there. It's a chain transfer.
Impugned order has been stayed.
That's correct.
The only advantage which he is gaining is that every action has been done on the teeth of an order of the interim order.
Right.
On the teeth of the interim order. That is the only ground.
Passed by the honorable single judge.
Your lordship must have seen.
If order is a nullity per se,
the entire administrative arrangement
does it invite the violation or contemptuous act?
No. It does not invite.
Then we'll go to that extent.
Yes, it will not invite the contempt of court.
It is a nullity per se, cannot be done.
Yes, my lord, your lordship is correct. Absolutely, my lordship is right.
Find out a place for him.
3 months are left for my retirement.
No.
That I can do.
You will get your salary, all the back salaries. We will direct. Everything will be done because you are not at fault. So in that situation, we will definitely take care of that. There is no doubt about it. Find out a place for him.
I'm looking into it personally, but one thing, may I request your lordship, let there be a judgment on this. Silpi is the leading judgment, your lordship.
Your lordship won't worry about it.
Yes. So this kind of administrative bottleneck, Millard, it can't be entertained in a routine manner. Is basically your lordship is absolutely, these are all executive proprieties where is to be, who is to be.
I tell you very frankly, at least 3 months before, both of us delivered a judgment. Day before yesterday we delivered a judgment that the court should not pass a blanket interim order without recording a reasons.
True.
The reason is indispensable.
Right.
The court, at least 3-4 lines, the court will write that what is a prima facie case,
right.
What is the irreparable loss and injury, what is the balance of convenience and inconvenience, and above all 3 golden parameters.
Right.
4th is the jurisdiction.
Right.
So the court will record.
Correct.
If it does not record, then what? Kranti Associates, all these judgments, Morgan Stanley, Shiv Kumar Chadda, everything be highlighted of the Supreme Court.
Correct.
Yet, what can I say? Have you seen the nature of the interim order? Not even a discussion on the facts. Interim order. It appears to me that it was only simply on the drop of the hat. It was passed.
Maybe
This
pardon my-
scenario cannot be accepted when the law is that you'll have to record the reasons why you will not record the reasons.
Because my lord,
We have been recording the reasons we have seen from the day one. Whenever the interim order is passed, we record the reasons why we are passing an interim order.
No, my lord, there are grave cases where the court's immediate intervention, we are not opposed to it, but that discretion, your lordship, is that
But you must
unfettered is
record the
there.
reasons for that.
Sure, but therefore this 15 days period is there the moment the application is filed, the court may take it up or there is a deemed vacation.
As it
But-
appears from page number 41,
My lord.
that starts from page 40, Panchayat Raj Department notification. There it says, it says, Bharat Kumar Mahapatra was in Bargarh.
Botpalli Bargarh.
Verbally,
Which?
No, that is transfer process.
No.
See
So
that.
the present posting
Present,
is Bargarh and he was transferred to Barpali.
Bargarh.
No. Saroj Kumar Mahapatra, Botpalli Bargarh. Botpalli is the place, Bargarh is the district.
Understood.
To Bhotli Bargarh.
So that's, 2 to 5 yesterday.
Lordship had directed. The difficulty now they are facing because of the interim order in the present writ appeal.
Please,
What is
that
in
one.
the writ appeal? What is the interim order? What is the interim order?
Stay operation of improved order, my.
Yes, obviously this has to be because we do not. That is what we passed and we recorded the reasons that why we are
If
passing
the
it.
then if the judgment has been stayed, there is no bar to implement that.
Interim order by your lordship is not a bar to give.
And what I indicated, the learned advocate general has also, we have recorded that in view of the question of law with respect to power to intervene in a transfer order passed in the administrative capacity is raised. As an interim measure, we stay the operation of the order. We said that how can
Correct.
judicial intervention be done in an administrative site so far as transfer is concerned.
Look, that's the consistent approach of the apex court. Silpi is the leading judgment, your lordship.
It's one.
Good kind of, now he is totally everything.
Yes.
Bharat Kumar, is now willing to work anywhere.
Could you find out a place?
I'll personally be. Let
Please
me
find
speak
out
to
a
the
place for him
Panchayat Raj side.
anywhere.
The Panchayat
He is
Raj.
very fair.
Lord, I'll get it sorted by the end of the day. I'm talking to the
Please,
Panchayat.
please sort out. We are keeping this
But
matter
your
on Monday.
lordship, may I
We
request?
are keeping this
Huh?
matter. And
Your
we will
lordship,
dictate with
yes.
the open court. Don't worry.
No, my lord, your lordship may clarify one thing. What my learned friend is suggesting. There is an interim order. There may be confusion. Your lordship knows this executive
Please,
at
please
times.
consider. I think the Mr. Das has not understood what.
Right.
We do not say that you pass an order.
That's correct.
What we say that you find out a place where he can be, and we know how to pass.
I'll get it sorted. Let whose client? Manoj.
No,
Bhai.
the
Huh?
junior
You meet
lady
me.
advocate who is appearing. Yes,
You meet
her
me
client.
during the lunch hour. Let me know what is the problem. I'll get it sorted, my lord, by end of it.
You just find out a position. You need not have to pass an order.
No, my lord,
Find out and tell us that he
by
can be
Monday
passed.
you will see.
We know how to pass it. What?
May not make time to keep it on Tuesday. I have some other envy.
You are showing a concern for your client.
Right.
Be reasonable for him.
Yes.
Come on Monday. In the same position on Monday.
Item number 2.
Left it. What is this?
That factorial installation of petrol pump, your lordship, on the last occasion.
Just to recapitulate the fact. Oh.
he is its CBA. So
He is the intervener, my lord. He is the intervener because
Order number? Where do I get it? Order number? No, order number. This order, 14 no. Sir, you,
intervener, my lord, was also contesting the writ petition.
sir, it is a most pertinent defect which cannot be ignored.
Sir.
You are a non-party to
No,
the
no.
proceeding.
Sir, that is the problem. For that, the matter also listed. Because I was the intervener. Because so far the property.
Whether you were allowed to be added as a party in the writ petition,
But
show us the order of impleadment.
No, we
as
are
a party.
So we are contesting. We have filed our mokalatnama.
How?
That has not been accepted by the honorable single judge.
Will not. If you are not arraigned as a party, mere appearing will not do. Then the provision of Order 1, Rule 10.2 of the Code of Procedure has to be completely overlooked
But
or to be deleted from the Code of Procedure.
Sir.
The only reason is a person can be allowed to be intervene or to be impleaded if he is a necessary and proper
necessary party here. What happened?
proper party also.
Yes,
not
proper
necessary.
Sir.
If you are neither a necessary nor a proper party,
Yes.
if the court will not permit you,
Sir,
then
sir,
you
sir.
file a Vagalandama not,
So,
then you are a non-party.
sir,
If you are aggrieved by an order, you have a right of appeal.
sir,
But unless you file an application seeking leave to appeal, the appeal is not competent.
with that observation can be disposed of also. With that observation, what happened? I will tell the fact,
What
my
are
lord.
you talking about, sir?
Sir,
Dispose of means? Do you realize the impact?
Sir, so far the fact is concerned like that.
We do not want to hear any fact. The leave to appeal application is not filed.
Yes.
You were not impleaded as a party. You are a third party to an proceeding. You have to seek. Not come. Not come.
My lord also allowed to withdraw, granted liberty to file a leave application.
Sir,
At page 46, that's the order of this honorable court, which has not been complied with, as a result of which this contempt application belongs. Page 46, Annexure 6. May I read?
what?
Page 46, Annexure 6
Yeah.
is the order that was passed by this honorable court. No, not blacklist. Your Lordship will remember, your Lordship has also dealt with several of these cases. A reported judgment is there of this honorable court on the self-same issue. Now, against that, the state government went to the honorable Supreme Court. The Supreme Court has upheld your Lordship judgments. Consequent upon that, this writ application has been filed because they have not adhered to the order of this honorable court as per Annexure 6. Now, may I just
Now
read?
they have said that the office memorandum dated 7/6/21
Yes.
under Annexure 8 modifying the office is quashed.
1911 is quashed.
So,
So-
no, 7/6/21 is quashed.
Both. 7/6/2021, 1911, 2019 is quashed.
Yes.
Now, that was my prayer in the writ application. Then my escalation bill has been held up, and your Lordship will kindly see.
So
Accordingly,
what it says that accordingly the writ is written in terms of the judgment of the BKD infrastructure. What more?
that also that has not been complied with. This order is dated
So
5/2/2024.
This is a contempt.
Yes.
Okay. Why you have not complied?
There is no direction. The circular.
No.
in
In
BKD
terms
also,
of the judgment render,
no, my lords, in BKD also there was challenge to the circulars, my lords. That circulars were quashed in BKD judgment at page number 43. My lords, there is no direction, my lords, to that effect because the
I will
2009.
remember, I will record your submission
No, my lords,
that that the consequential effect of the decision, unless expressly indicated in the judgment, shall not be followed by the authorities for all time to come.
no, my lords, here.
Will record.
No, my lords,
We'll
here
record
what
your
was
submission.
under challenge was circulars of
Madam, you
escalation.
did not understand what I want to say. If the circular goes, if it is caused and set aside, then the impact or a consequential or incidental effect have to be considered.
Whether he's entitled or not entitled.
Your lordship will kindly read
Maybe
paragraph
you
4.
not.
Yes. Sir,
So,
let's take instructions, my lords.
What instructions, my lord?
sir, it's a technical contempt. I'm telling you, the order does not really speak so. It is a logical inference one has to draw from this observation.
With your lordship's permission, can I submit for 2 minutes, please? I was awarded a work, 3 minutes.
3
Okay, I am grateful. I was awarded a work in 2015 to be completed by 2018. Done.
As compliment for that.
As per the terms and conditions of the contract, I was
Yes.
May I please, Lords.
Give mining and yes, sir.
Let two issues primarily. Let I spoke to the learned Attorney General. Actually, he was supposed to address your lordship today, but he's inconvenienced. So last occasion I discussed with him, your lordship may give a suitable date as per your convenience. So, but primarily, Milan, the issue which the other side they have very extensively argued for 1, 2, 3 hearings. Let me be precise, very to the point, objective, and we have to make it short. The ground of attack on the demand of the state, so far it pertains to the penalty for non-performance, which basically Milan in us from Rule 12, capital A of the MC Rules 2016. I'll go to that little later. But your lordship knows the most tragic part in the history of the mining industry sector in Orissa, which led to the judgment of my Lord Justice Lokur in common cause case. The very opening paragraph was disastrous. But if your lordship would permit, I will begin my submission with that paragraph of Honorable Justice Lokur, the great judge, that it was a mega box. The entire Keonjhar, Sundargarh, and the Mayurbhanj district of Orissa, the mineral bearing areas of the state, Milord, they were rapaciously looted by those so-called miners. This is the language. This is not my language. This is the language of the Honorable Apex Court. Let the reference, let me begin with this because
There is already
I have read this,
given. No?
the reference, Milord.
No, we have been provided with a copy of that.
No, Milord, in fact, I was not, because I thought that your lordship will not be sitting after recess because of the arbitration bench. So I was informed by my officers.
The fault on the part of the registry.
No issue, Milord. I was prepared to argue.
fault.
So, therefore, Milord, the reference is 2017 9 SEC page 499. Milord, only one paragraph. I am not going to the whole judgment at the moment. But why do I bring it to your lordship's kind notice how attempts are being made to defraud the exchequer? Somehow or other, your lordship knows that mineral resources are the national resources, and the major revenue which mine state gets are from two sources primarily. from the mining sector and the GST. That is how the state survives. Each one of us depend upon the revenue and the what we call ultimately the public sector. And here, in all these 6 cases, my lord, the demand would be more than 5,000 crores. Exactly, maybe 6,000 crores. I'll come to that. Similar this 2017 Common Cause judgment that opened the eyes of the entire nation, that led to the drastic amendment of the MMDR Act of 1957. Lord, entry 53 of list 1, your lordship knows, authorizes the union government to legislate on the issue. Exactly say para one kunega. Asialan, but I don't know. Lord, I have made ready 2 copies of the judgment. Lord, your lordship knows this common cause.
Yes, yes, that was placed.
Yes, a public
on the last
spirited
of
body.
also.
They have taken off many laudable causes, and
now,
one
just
such
now it has
judgment.
been taken out.
That's
The
correct.
print has been taken out just now.
Yes. So this led to Saha
The
Commission.
warmth can be felt.
That we, Lord, there is a.
Not
If your lordship,
warm. It's a warmth, I can say.
no, my lord, there is a story. If your lordship would permit, I would make a lighter vein.
Yes.
I, my lord, inquired how the case diary is being transmitted to the petitioners' counsel. I called one of the SO of my office, asked him that they touch the papers. If it is hot, then suddenly the police officer along with the accused, they go to the Xerox room and give it to the. So therefore, it is not that way, my lord. So it is hot, apparently. So, but this Justice Lakur, my lord, opened the eyes of the entire nation that led to a drastic amendment of the MMDR Act, leading to this, my lord, from the conventional grant of the lease to the auction regime. Section 8A.
2015.
That's
came.
correct, March 2015,
Yes.
my lord, that the virus was under challenge again by the same common cause, and that judgment I am for the time being not referring to. I'll come to that little later. But the facts reveal, your lordship, look at the indulgence of the Apex Court. The facts revealed during the hearing of these writ petitions. Please allow me. I get disturbed if there is a murmur. So that's a bad habit with me. So the fact revealed during the hearing of these writ petitions filed under Article 32 of the Constitution suggest a mining scandal of enormous proportions and one involving megabucks. The lessees in the districts of Keonjhar, Sundargarh and Mayurbhanj in Odisha have rapaciously mined iron ore and manganese ore, apparently destroyed the environment and forests, and perhaps caused untold misery to the tribals in the area. However, to be fair to the lessees, they did the detailed steps taken to ameliorate the hardships of the tribals. But it appears to us that their contribution is perhaps not more than a drop in the ocean. Also, too little, too late. But this opened the eyes of the entire nation. So this 2015 amendment, my lord, which is, my lord, very, very progressive. Your lordship may, if you look at this second renewal, first renewal, second renewal, third renewal, pending, my lord, at times, my lord, bureaucratic apathy and kickbacks, everything, my lord, that put an end to that. Transparent auction regime, my lord. You come, participate in the bid, offer your price, achieve the target, explore the minerals, develop the minerals, and without production dispatch, how it is to be dealt with, that has been very vividly dealt with in enormous provisions of the MMDR Act and the rules framed thereunder. I'll go one by one. But the basic contention which the other side very vigorously wanted to pursue before your lordship is that Rule 12A does not include the word dispatch.
No. It includes the word dispatch, though.
So they have no obligation. I'll come.
Dispatch is not there in the Parent Act. That is what.
No, Millard, it may not be. It is very much there. I'll come to that. Millard, they sometimes, Millard, we, the lawyers, we look at the provisions of the statute from our angle, not from the angle of the makers of the law, who, Millard, basically drafted the legislation for the countrymen. I will, Milord, from that perspective, because it's a state resource, it's a national resource. So it's my duty as an officer of the state to point out that what the lawmakers really intended. Milord, production doesn't mean I will just explore the mineral, keep it pending in the leasehold area and undispatched. Milord, revenue is basically royalty. Royalty, Milord, is payable on the quantity dispatched, not on the quantity produced. So, Milord, I'll take your lordship to different provisions. So, at the time being, Milord, for the time being, let your lordship first come to some of the provisions of the MMDR Act in the definition chapter. Milord, object I in a nutshell I highlighted before your lordship. I will not take your lordship to the lengthy legislative intent of the 15th Amendment. But before that, Milord, your lordship may look at the 4 important definition provisions of the Act. এটা কোন? এটা Milord. Okay. একটা না? কোন বলছো? Milord, your lordship may kindly come to section 3 of the Act. This section 3 deals with the definition
Yes.
of different. We are concerned with, Milord, the word dispatch. 3 double A, small double A. Dispatch this in this act unless the context otherwise requires. Dispatch means the removal of minerals or mineral products from the leased area and includes the consumption of minerals and mineral products within such leased area. This is how, Lord, your lordship may then turn to section 3 FA.
3
FA, Milord.
Yes.
3 FA. Lordship got it?
Yes. Production.
Production. And Milord, this 3A and double A, lordship may kindly, 3A and double A, that was inserted by way of
From 28/3/2021.
absolutely right, Milord. 28/3/2021. It was initially not there.
And correspondingly, FAA was also amended.
Absolutely correct, Milord. The same by the same enactment,
Correct.
Act 16 of 2021. Production or any derivative of the word production means the winning or raising of mineral within the leased area for the purpose of processing or dispatch. Both. So, Milord, let me just give an example. Milord, mineral, there are stages. First, it is to be explored, produced. Production, Milord, means it is to be extracted from the leasehold area. Then the Milord, detailed procedure, how it is to be stacked into blocks, etc. I am not going into that. So, Milord, mere production does not generate any revenue because the royalty is leviable on the quantity of the dispatch, mineral dispatched. And Milord, there is, in essence, there is no mineral development. Milord, the very word associated with the word mineral development, Milord, it includes imports that it is to be produced and dispatched. It is to be used for the purpose a mineral is supposed to be, it is meant for. Otherwise, there can't be any development of the mine sector. Their obligation, they say, against the moment we take it in auction, produce the mineral, keep it in our leasehold area, and evade the royalty part of the exchequer. It is not like that. So therefore, consciously when this particular earlier, it was mineral production, the word that has been substituted. I will show your lordship the pre-amended provision, mineral production. So consciously the parliament, my lord, inserted these words that in some of the miners they took with high price, did not operate the mines, kept it idle for 2 years. So therefore, my lord, the non-performance or, my lord, the non-dispatch is always visited with consequences, penalty, my lord, either with lapsation or the termination. I'll go to these two provisions separately. So therefore, my lord, this production and dispatch, if your lordship would read both the definitions conjointly, this, my lord, 3AA and 3FA, which, my lord, came to be inserted in the statute by Act 16 of 2021 with effect from 16th of March 2021, my lord, it would definitely lead to the irresistible conclusion that the mineral exploration or development is always associated with production and dispatch, because the royalty accordingly is to be levied on the basis of the quantity to be dispatched, which is the minimum requirement under a separate agreement. I'll come to that. And let us for the time being forget about any kind of agreement to be but the performance part is very in itself is in is contained in the lease agreement in the schedule 7 under the framed under the rules. I'll come to that. Your lordship now may come to some of the substantive provisions like section 4 subsection 4 of section 4A. Your lordship may look at the whole section, not necessary, but section 4A, subsection 1, then 4. Termination of licenses, prospecting, we are not concerned. Exploration license or mining leases, we are concerned with the number 3, Millard. Where the central government, after consultation with the state government, is of the opinion that it is expedient in the interest of regulation of mines and mineral development, preservation of natural environment, control of floods, prevention of population, or to
That is
avoid
in relation
danger
to a premature termination of those.
That's
deals.
correct. So therefore,
on the advice of the central government, the state government is
that's
obligated.
correct. So, Millard, what I precisely, Millard, let me just crystallize here for a moment. Your Lordship knows that with your Lordship's vast knowledge in civil law, this leads by itself, Millard, it's not a permanent grant of any right. It is subject to certain performance of obligations and conditions of a contract that is always in non-permanent in nature. These are the conditions you obey, you respect. If you flout or defy or fail to perform, then the consequences will follow. That is always there in every lease. It's like a grant. So therefore, that consequence has been provided in subsection 4. You perform, otherwise you perish. So this is how the legislatures intended to engraft in subsection 4, where the holder of a mining lease fails to undertake, your lordship may kindly look at the language, fails to undertake production and dispatch. But this is very important. And the rules are always subservient. The old and the settled proposition that the ocean seas, river cannot surpass the sea, that, Milord, it is ingrained. The rule, Milord, it is to supplement and supplant the substantive provisions of the Act. And the very word production and dispatch, Milord, engrafted in subsection 4, which came to the statute book by way of amendment. And that to, Milord, with a further obligation that 2 years, this is the period you perform within these first 2 years, and because that would be the test of your performance report, it's like a proposal probation. So this is, Milord, in even in service jurisprudence also, Milord, there is a probation period. You perform or you go. So therefore, these 2 years moratorium period, casting an obligation on a lessee that here is a mandate for you You do this, produce and dispatch. If you fail, face the consequence. Either you face a termination or there is an automatic lapsation of the grant which you are being given by the state.
Because this
Not-
word
Yes.
production and dispatch, this word has been substituted in a contemporaneous period of time
Time.
when this section 3 AA and FA were introduced,
Right.
found from the book.
Right, right.
Now,
Right, Milord.
when a word
No.
and is used between the two words,
No, Milord, the same. 7 also this production and dispatch in subsection 4.
I'm just wanted to
Right.
have your opinion on that. That the word is a collective word, production and dispatch, which
Right.
were brought.
Sorry, Milord, I couldn't.
Is a collective word, production and dispatch, conjointly. They were brought. Now, when the word and is used normally, I would
Right.
say, or ordinarily, I must say,
Right.
that connotes the joining of these two
Right.
words. When you talk about a production or a dispatch,
Right.
it's a different concept.
Right.
When you talk about a production and dispatch,
Right.
then the termination of lease
Right.
must be done if there is a violation in this regard.
True.
Just a hypothetical, this out of box that came in my mind, just to understand the things more clearly. A mining leaseholder produces, does not dispatch.
That is what the crop.
So there comes a violation of one of the component
Right.
of subsection 4, which says you can't say there was no production, but you can definitely say there was no dispatch. So if the production and dispatch are conjointly used, then it must be a violation of both the production and the dispatch contemporaneously. There cannot be a segregation. Has it been a word or, so mere production will not do, mere dispatch.
Will not. No. Dispatch is not possible without production.
I'm saying
Milord, dispatch is
that's the whole
followed. It is to follow production.
Yes.
Milord, what they contain,
Sir,
production we will do, dispatch is not our obligation. How can then, how
why-
do I
that-
collect the royalty?
I was just thinking about and.
it is not your fault. The production is for dispatch,
Production?
is for dispatch.
Of course, Milord, that is what my mineral development is. That is what the mineral development is. Mines are not to be kept idle. It's like prithvi khata nikhatena dhanena dhanena. If you, then what is the meaning of the mining operation? Mining operation, Milan, what does it mean?
Why this question was put? Because one of the argument which was advanced from the petitioner side, that look, this dispatch means the sale of those ores or the minerals.
Milord, I have answered for all their arguments. Your Lordship may give me patient hearing. I have crystallized each and every. I have very good answers for each of their contentions. There is no issue at all.
I just thought that
problem non-issue. They want to evade the revenue. They want to evade the defraud the exchequer. I will explain one by one. Milord, Rule 12A, Milord, common cause, your Lordship knows this particular provision has been illogized. This tendering process is so transparent. You have, Milord, earlier what was happening? They were taking it, mining rapaciously the word the Supreme Court has used. They were, Milord, keeping it pending. Your 6-7 petitions, your Lordship, were in session over the matter. They even dispatch. Now that has vested in the state. After the expiry of the statutory period 31/3/2020, 6 months 12/1 GGHS, they come before extend time for a dispatch. So, Milord, therefore, this minimum obligation of dispatch has been engrafted in the statute itself, that you are under a obligation, you produce this much, dispatch this much. If you fail, then reap the consequences. There is no escape. Now, Milord, when hundreds and thousands of crore, Milord, one of the lessees, Milord, he took it in a very high premium, did not perform. 29,000 crore is the pending due. He now comes before the court, says that I will pay now 129,000, permit me to now mine. Milord, this is playing fraud on the staker. How does the state survive? How do we survive? Because it's a welfare concept. Your lordship knows we have a state has several obligations. These are the two revenue sources. Let you leave. If you fail to perform, you leave, people will come forward. Who is compelling you to become a participant in the bid? You came, it's an open auction, you offer your bid, take it, and do not perform. Now you come that no, I will produce, I will not dispatch. Let it be kept idle. How do I get the royalty then? Royalty is payable. I am going to that calculation, Miller. So therefore, this minimum production and dispatch is a basic requirement of, suppose Miller, a sand query. Somebody will take it. Royalty is payable on the quantity dispatched.
With all humility, I
Yes.
think that's a digression from the query which I raised on the basis of this particular subsection 4 of section 4A.
Right.
I'm not concerned with whether the production or the dispatch should be there or should not be there, whether it should have been incorporated. We are not concerned with this. When you were referring subsection 4 of section 4A, which postulates that if you do not do a production and dispatch, it may, or for a period of 2 years,
Right.
it invites a termination of your lease. So
Absolutely.
this is the consequences which are
Right.
provided for termination of a lease.
Right.
I was just having a query in that regard when the
Right.
production and the dispatch are joined together by using the word and. So let us understand
So
what
that
should
is
be
that
the
is
correct
Miller.
proposition
So
of interpreting this expression,
yes.
production and
Miller answer
dispatch,
yes. Product
to
they
mean
are yes.
default on any one of it, or it is a default as a whole,
No, Miller, it is
with the
to be
production
it is
and the
combined.
dispatch,
Millard,
and then the
I
word
get you.
and has to be given a
That's correct.
conjoint
That is why
meaning.
it is and.
That is what
That
I'm
is why
saying.
or not or.
I just wanted to
Dispatch,
say.
production or dispatch.
Now
It is
their
and.
argument was
Yes.
that there is a resources. I am making a production, but the dispatch is always dependent upon a demand in the market.
No, it is not inconsequential.
If the
It is
demand is less, I may not dispatch.
It is Millard, it's
So in
in
that event,
Millard, it is their concern. It is not my concern.
that's
Millard,
saying
this is
that
the obligation.
concern is
Millard, there
to
are
interpret the
in a
provision
lease, Millard.
in a proper manner. That is what I'm saying. So
In
according
less
to you,
Millard,
should I take it that this production and the dispatch, the production and the dispatch, both are contemporaneous to each other. They complements each other, and both cannot be segregated. And one is really a synonym of another.
it is not exactly Millard synonym.
Why I say so?
No, no,
Millard,
no,
then I
that,
come to
no,
the
no,
definition.
it is,
They come to the definition of a
no,
production.
synonym or
three.
Millard, it is not a question. Millard, two
Come
things.
to the definition of a production in section 3FA. I'm talking in your favor.
No, no, I got your point.
Please come to the definition of a production.
Production.
And the last word is
Yes,
used in the
for
definition.
the purpose of processing or dispatch.
Now, once it also includes a dispatch within the definition of a production, then what does it mean?
No, Millard, you will achieve two things. Let me be clear on two aspects. Millard, production has been defined, dispatch has been defined. What is production and what is dispatch? That has been defined. A mineral resource is not meant to be only explored or for the production of the ore. Whatever, iron, manganese, bauxite, whatever. Ultimate object is to fetch revenue to the states, because the state has to get adequately from its own resources for the benefaction of its subjects. That is the ultimate cherished goal of the exploration of the minerals. So now, Millard, a particular lessee, he is not at liberty to decide the terms and conditions of the lease. Statute itself is not self-contained, and it contains in eloquent words that here is an obligation for you. You perform or perish.
These are very fundamental.
There is no question of any option with the lessee that it's under my option. I will produce, leave the minerals in the leasehold area. The state
There is no distinction.
That's correct. That is where the case ends.
There are two types
And
of
that means
leases.
your lordship have
There are
already understood
two
the
types
point.
of
Why
leases.
should I argue and
One
waste
is
your
a-
lordship's public time? That is the
There are
not,
two
that's
kinds
the
of
that's the
leases.
point.
One is a contract.
This solitary point, I need not waste 3 days time, my lord. That's
Is
the
the-
crux.
Oh, you are.
That's the crux.
That you
No,
are.
no, I am grateful. Your lordship have cut the point. It is not a question of discharging the obligation one part, abdicate the other. Produce and dispatch. That is the requirement of a lease. Either you perform, I repeat, or you perish. There is no question of any option left with a lessee that no, I show me, Lord. I'm sorry. At times, Lord, unless the courtroom is surcharged, my Lord, your lordship always says that my Lord, push, then argue, then I am doing that. My Lord, your lordship is provoking me at times, so I am get provoked. Sorry.
Why you get provoked?
I am not provoked, my Lord. My Lord, ultimate aim, mine, your, everybody, my Lord, is to of my Lord, that is to protect the public.
Oh, no doubt, sir.
We are all performing public duty, my Lord. You are
Absolutely.
me, everybody.
Absolutely.
It's not naturally, my Lord. So
Hmm.
ultimately, we have to see how the
And-
exchequer is
and
protected. It
we
goes
were
to the
very-
common man,
and we
not
were
to the hands
very
of
happy.
people.
Just 1 minute. To all of them, we were very happy when in one of the symposium you have correctly said it is not the losing of the state, it is the losing of a people of the
No,
country.
no, here I will lose, my Lord. If I lose
That is what I remember.
my Lord, Brahmasva, Rajasva, Devasva, my Lord, your lordship knows that no cost I will live. I may leave a poor man, I will not leave a bourgeois.
So,
My Lord, a lessee,
that
your lordship
means-
knows they exploit the natural resources, they will evade the revenue. I will not leave. This is the last priority.
You are then going a little digression. After all,
No, this is not the example, Mila. I'm sorry. I correct myself.
I'm
Yes.
thinking.
Yes.
Rajashwa
Yes.
is for what? To be utilized for the benefit of the common people of.
Absolutely, Mila. That is for the common man.
Ultimately, it goes to the common.
It comes from them, goes to the common man. So they want to obstruct.
It is
That's correct.
what the people who loses. It's what the people who wins.
Milord, it is not anybody's property. It is state's property. It is common man's property. It is your lordship property. It's state's property.
There is a
Some people are the intermediate.
Then it is the
Beneficiary, highest beneficiary. Now they want in some garb, this rule is bad, this section is this, so therefore, Milord, that is clear.
Right.
So
now we have to rise then.
Rise, Milord. Therefore, I was proposing, let it be sometime in last week of January, because
no, last week of January, no.
Any day, but no,
sir,
fast.
Today I am at fault because of them.
No, there is no
when
fault.
this matter was especially fixed, it ought to have been at
your
number one.
Is doing judicial
should have been number one.
No fault.
If they have not done it, I can't say anything.
But the problem is first week of January and second week I have already kept so many matters in the appeals court. Therefore, I thought that Attorney General will be doing today. So day before he requested that Acharya, you kindly continue.
May I have the indulgence, May I have the indulgence, the Supreme Court is closed from today, so we are all free if the lordships are.
I am going out.
For 21st.
You have already. We have to also get some holidays, Mr. Dwivedi. I am for the my wife has.
You are fighting for Rajaswa, so you must be ready to argue.
Till 2nd of January, I'm out.
Well, I don't think we can get into all this with your lordship. It's your lordship prerogative. But only thing is, the original understanding was that the learned AG would argue and that we'd reply on 22nd. Your lordship were kind enough to reserve that. Now, Maharaj, the other learned AG should probably fill up that and finish it, but he doesn't want to argue now. Then your lordship will give Maharaj some date down the line.
He doesn't want. He is inconvenienced today. Please, Mr. Singhvi, that's not the.
Only
Milord,
Very well.
it's my demand. I have to. There is no bar.
I
If-
appreciate. There will be a-
Sir, he is already there, Milord. Attorney General
just-
is
Then
there.
your lordship
I
put it
just
towards the end of
logged in.
January, etc.
I just logged in. I'm sorry for the inconvenience caused to the court. Nothing is intended. Nothing is really intended.
That's correct.
Then have
Let
it
me
towards the
finish,
end of
Milord.
January,
Let me
Malus. End
finish.
of
It's a
January.
state's demand. Let me justify.
Let's
Let-
send,
End of January or early February, Malus, whatever.
He is the main, I think he wanted to argue. And he has requested the AG now to argue. So let him.
Milord, it is the all the same. Either whether my senior does, I do.
What is the
But-
date? Just tell me.
Then let it be towards the end of January, etc., suitable to the AG and your
Same
lordship's
thing I was.
8th and 9th.
January.
8th and 9th.
Yes, end January.
End of January will be too
Early
far.
January.
Early in January is what we decided earlier.
Yes.
Either your lordships can have it on 8th and 9th of January or end of January.
Yes,
No,
8th of
Milord.
January.
I can go with
Milord,
I'm just-
London,
I'm-
Attorney General,
please-
no,
No,
the first
all of
week,
us-
second week.
All of
Ma'am.
us know that our calendars, I mean, it can't be one-sided. So therefore, I'm sure my learned friends cannot oppose on the other side. I am trying to find out an earliest date possible. And therefore, either it's possible on 8th, 9th, otherwise it may have to go to the end of January.
We are fixing this matter for you on 8th and 9th. You come and argue the matter. We'll see if the AG has.
It could be on 8th and any one of those 2 days.
Milord, already in the first week, I have some matters in the Honorable Apex Court. It's already fixed. No issue, no issue. Let my Lord Senior. Milord,
Personally.
1 minute.
Milord, I do not want to. Milord, I do not want to miss the opportunity of hosting my Lord Attorney General. I have to be here. He can't.
Keep it on 8th and 9th.
So 8 January, no issue.
2 days we have fixed.
Or
So
the
one
interim,
day, Milord, will.
the interim
Your
also
lordship,
Attention
my
on
lords are keeping it on which date?
8th and 9th.
8th and 9th.
Okay, very well.
8th and 9th. We are keeping it on the 8th. As a first case.
On 9th?
8th and 9th, first
Well,
case.
8th and 9th.
Very well.
First case, Milord, at 2 p.m. your lordship.
No difficulty.
Milord, 2 p.m. Milord, 2 p.m. would be good because first half other lawyers will not be affected.
There is the first half. What is the difficulty, Mr. AG?
No, I don't have any difficulty. I am Milord for this. No issue, no issue. Any time.
Yes.
Deeply obliged.
Grateful.